Good morning, everyone. Welcome to this joint hearing of the Chemical Safety, Waste Management, Environmental Justice, and Regulatory Oversight and the Fisheries, Water, and Wildlife Subcommittees. We're here to receive testimony from several witnesses about Senate Bill 3571, the Good Samaritan Remediation of Abandoned Hardrock Mines Act of 2022. The history of the West is the history of mining. Mining for gold, for silver, for copper, and for nickel and more. In my state of Oregon, mining of these minerals gave birth to whole towns after the first nuggets or veins were discovered in the 1850s, and prospectors and fortune seekers from California and other far reaches of the world came searching for these metals. In the century between the 1860s and 1960s, Oregon mines produced somewhere in the range of $130 to $250 million, which in the currency of the time was a lot. But over time, most of these mines dried up or ran out, and when they did, they were abandoned and the towns that they created died. But the mines that gave birth to them live on, leaching various chemicals into the watersheds and nearby streams, impacting many different tributaries and many different tribal and environmental justice communities, and there's no one taking responsibility to clean them up. There are some estimated 140,000 abandoned hard rock mining features throughout the United States. Federal agencies have found that 6 in 10 are known to pose dangers to physical safety or environmentally hazardous. This means thousands of miles of streams are impaired by heavy metals or acidity from these abandoned mines. The Environmental Protection Agency also estimates that abandoned hard rock mines are impairing water quality in 40% of the headwater streams in the United States, or the western United States, 52% of which are also drinking water sources. There's a critical need for us to address these abandoned mines, to clean them up, to stop them from polluting our waters, and in some cases, reutilizing the very areas they are in some way to benefit communities, such as utilizing them for fields of solar panels. The question is, how do we do that when those who were responsible for the mines initially are long gone? The task is so daunting that the Bureau of Land Management estimates it could take up to 500 years just to confirm the presence of physical or environmental hazards at the abandoned mines they already know of. And that's why last year we sought and authorized $3 billion in investments for cleaning up and reclaiming abandoned mine lands as part of the bipartisan infrastructure law. But more clearly needs to be done, and we need to work with those good Samaritans, state agencies, businesses, nonprofits, environmental groups, and others willing to take on this task. As things stand now, however, it's not easy to do so. Any group that works on a particular mine takes on potential liability for the pre-existing pollution. And that's a challenge that this hearing will seek to address. The Good Samaritan legislation we are looking at and the pilot program it creates would seek to limit that liability for projects with low environmental risk, which will improve water and soil quality and otherwise protect human health. So this hearing is an opportunity to explore, to understand the merits of this strategy, to understand better how it will correct a multi-generational environmental hazard, and to consider suggestions for improving the legislation, and to ensure that there's appropriate oversight and input from states, tribes, and other stakeholders. So I want to thank all of our witnesses for being here, as well as the interest and engagement of both subcommittees. And with that, I'm going to turn things over to Senator Lubmas, ranking member of the second subcommittee, for any opening remarks she would like to share.
Thank you, Chairman Merkley. It's Great to be here with you and join with your committee, the CSWMEJRO committee. That is quite an alphabet soup. And lovely to be with Senator Heinrich, who is one of the sponsors of this legislation, as well as Jim Augsbury from the Western Governors Association. It's nice to see you again. This legislation and hearing is the culmination of efforts by a lot of members and outside support groups, including some of those represented here today by our witnesses. And so, again, Senator Heinrich, it's great to see you here today. Senator Risch is also co-sponsoring this important bipartisan legislation. It's a pragmatic solution to the challenge of approximately 550,000 abandoned mines across the U.S., costing an estimated $54 billion to remediate. And it's just amazing how long this has been going on. It's time to get after some of these. While most of the sites don't pose environmental problems, drainage and runoff from some of these may pose a threat to surface or groundwater. So this bill creates a 7-year pilot permitting program to allow for 15 Good Samaritan remediation projects on federal, state, tribal, and private lands. And by resolving the liability issues that Senator Merkley mentioned that come under CERCLA and the Clean Water Act, we can expect additional help from new partners that will both protect human health and improve water and soil quality. We want to make sure that no good deed goes unpunished doesn't apply here. Legislation like CERCLA and the Clean Water Act that are intended to protect the environment shouldn't be the very reason that we can't protect the environment. Mining has been happening in our nation for around 150 years, but most of that occurred before serious environmental regulation was in place. And while we have to address some of that legacy mining that lacked the incredible safety and environmental standards we use today, we also must recognize that mining is absolutely necessary to our way of life. From materials used in life-saving medical devices like CAT scans to defensive armor plates for our men and women serving in the military, mining impacts every single one of us for good. I look forward to hearing from our witnesses today how this bill helps solve some of these legacy remediation issues in a common sense way that also respects federalism and utilizes willing partners who are eager to help. So in closing, legislation to authorize Good Samaritan remediation has been around since 1999. That's a long time. We're going back into the last millennium. Something as bipartisan as this needs to be made a reality. I'm hopeful that just perhaps the alphabet soup combination of our subcommittees will be just the magic recipe to do so. Thanks again, Mr. Chairman. I yield back.
And taking leadership on this longstanding potential solution has been the lead sponsor. And Senator Heinrich, I know when you sponsor a bill, you also become an expert in it, and so we're looking forward to your testimony, and you'll be followed by Senator Risch.
Great. Chairman Merkley, Ranking Member Lummis, thank you for holding this hearing today on the Good Samaritan Remediation of Abandoned Hardrock Mines Act. And I want to very much thank Senator Risch for your partnership and leadership on this critical issue. Across the country, old, abandoned hard rock mines leak heavy metals and other pollutants into waterways every day. We've certainly seen this with the Animas River and its travails in New Mexico. These mines, which produced metals like lead and gold, iron and silver, contributed vital materials to the industrial development of our nation over the last century. And in fact, both my father and grandfather worked in this industry. But in some cases, the companies that operated these mines shut down, went bankrupt, or just disappeared, leaving behind mine sites that pollute our lands and waters. We should hold responsible parties accountable for pollution. In fact, any company that has a historical, legal, or financial relationship to a closed mine is required by law today to clean up that site, and that's appropriate. But there are literally tens of thousands of abandoned hard rock mine sites that are truly abandoned. No person, no company that was involved in the operation or the ownership of the mine still exists and can be held accountable for that site. These mines are just there, year after year, in some cases polluting our water and destroying habitat for fish and wildlife. Now, one factor that keeps unrelated third parties from voluntarily cleaning up these sites is that under federal law, liability for pollution cleanup attaches to any person or any entity that touches a pollution site for any purpose, even if that purpose is simply to clean it up. This means that organizations like Trout Unlimited, who you'll hear from later this morning, are unwilling to tackle mine site cleanup even when it's a major cause of fish habitat decline, because doing so could mean huge liability for pollution that they had no role in causing in the first place. Even state environmental departments often avoid cleaning up certain sites of abandoned mines because the liability risk is simply too great. So we need a new approach. The Good Samaritan Remediation of Abandoned Hardrock Mines Act would create a pilot program to allow the EPA to issue no more than 15 Good Samaritan mine cleanup permits. These permits could only be issued to third parties unrelated to the mine, and the EPA would have the authority to approve or deny the applicant's cleanup plan. The permits would be subject to NEPA and other environmental laws, but would relieve the permit applicants from being legally liable for the pollution that they did not cause. This legislation has broad support, including state environment departments, tribes, mining companies, hunting and fishing groups, conservation groups, local elected officials, and many more. We now have 18 bipartisan co-sponsors, including several members of this committee. This broad support comes from the fact that our community simply can't wait any longer to start cleaning up this pollution. So I hope we can pass this legislation soon and let these Good Samaritans get to work cleaning up our lands and waters.
Thank you very much, Senator, and I know you have a lot of such mines in New Mexico, as we do in Oregon, as we do in Wyoming, as we do in state after state in the West, and that includes Idaho, and we're delighted to have Senator Risch joining us today.
Well, thank you very much. I appreciate the opportunity to talk about this important piece of legislation and for you setting the hearing today. In my home state, mining has a long and a rich history, and that history is still being written today. Idaho, aptly named the Gem State, has produced world-class supplies of gold and silver from before its statehood, still does so today, and has produced minerals critical for defense needs from World War II through today. As we work to further advance security and clean energy capabilities and shore up supply chains, Idaho's supply of critical and strategic minerals will, without a doubt, play a central role. Today, mining companies are held to rigorous environmental and reclamation standards throughout the mining process and are able to safely and sustainably extract important mineral resources. However, this was not always so. Many long-abandoned mines, while once a major boon to communities across the West, now pose serious environmental risks without having a party clearly responsible for them. I'm honored to partner with Senator Heinrich, sponsoring Senate Bill 3571, the Good Samaritan Remediation of Hardrock Mines Act, along with, as Senator Heinrich noted, an impressive and growing coalition of bipartisan sponsors. This bill is a reflection of years of collaboration among interested parties or Good Samaritans with genuine will to clean up these abandoned mines. My undergraduate studies were in natural resources, and I've spent my entire adult life as a state senator, lieutenant governor, governor, and now here in the U.S. Senate, working to solve natural resource problems. I can tell you from experience, it is rare to have industry, conservation, and recreation groups rally around a singular uniting issue the way they have with this legislation. It's not unprecedented. In Idaho, when I was governor, we undertook the invitation from President Bush at the time to write a roadless rule applicable to our state. As you know, the roadless rule issue has been a vexing problem and continues to be a vexing problem all over America, except in Idaho. We wrote a roadless rule. When I say we, I mean Idahoans, and in collaboration with the various stakeholders, we wrote a roadless rule that survived a test in the Ninth Circuit Court of Appeals, believe it or not, and is the law today applicable in Idaho. I have to thank all of the parties that helped develop that roadless rule. And the type of support I had there and on this bill is a testament to how important and timely this bill is. We have good faith actors, and good faith actors are always a necessary ingredient when you're trying to do this. And these good faith actors are ready and invested in remediating these legacy sites. I'd be remiss if I didn't acknowledge my good friend Chris Wood, who's here today. Chris heads Trout Unlimited and was an incredibly valuable partner as we developed the roadless rule for Idaho and then went through the courts sustaining it. Chris purports to be an environmentalist. One of the little-known facts is that he makes a pilgrimage every fall to one of our western states to try to help decimate or decimate our elk herds. Fortunately, he's a much better trout fisherman than he is elk hunter. We owe it to our western communities and to all Americans who hold dear our vast public lands to empower and encourage them to do what's allowed under this bill. I appreciate the step this committee is taking to do this, and by discussing this legislation, and I hope it will be the first step in its swift advancement, which, as both of you have noted, is long, long overdue. Again, I appreciate this opportunity to speak on this topic. I appreciate the partnership with Senator Heinrich, and this is critical for communities across Idaho and across the West. Thank you so much for your time.
Thank you very much to both senators and your presence representing both northern and southern sections of western United States and representing both blue and red communities and states. Just shows how much range of support there is for this effort. Thank you.
Thank you.
We'll now ask the second panel to be seated. Welcome to all the members of our second panel. And we're going to turn first to Senator Kelly of Arizona, who has been deeply engaged in this issue and I know is fighting to find a solution that will help in his home state. Senator Kelly.
Thank you, Mr. Chairman. Ranking Member Lummis and Chairman Carper and Ranking Member Capito, thank you for holding this hearing today on the Good Samaritan Remediation of Abandoned Hardrock Mines Act. Estimates from the Arizona State Mine Inspector indicate that Arizona could have as many as 100,000 abandoned hard rock mines. Not all of these pose a risk to public health and the environment, but there are hundreds that do, including many on tribal land. Most of these sites predate any federal or state mining regulation. In fact, most predate Arizona becoming a state. And there are real risks involved here. For example, abandoned uranium mines, including those on the Navajo Nation, pose an acute health risk to those living nearby. And throughout Arizona, abandoned zinc, copper, and lead mines pose a risk to surface water and groundwater quality. At the same time, as we have this historic drought, these threats are threats to potential sources of drinking water, and they need to be taken seriously. Fortunately, the state of Arizona, and particularly our Department of Environmental Quality, has risen to the challenge, which is why I'm excited to welcome virtually the Director of the Arizona Department of Environmental Quality, Misael Cabrera, to join us today. Director Cabrera has spent his entire professional career cleaning up and protecting the environment. He's an environmental engineer who, before this career in state government, worked on environmental quality projects as a contractor with EPA, DOD, and state and local governments. For the past 11 years, he has worked at ADEQ, first as the deputy director before he was appointed to serve as the agency's director in 2015. Under his leadership, the ADEQ team has finished twice as many cleanups of hazardous waste sites than in the agency's previous 27-year history. He has doubled the number of leaking underground storage tank closures per year, and he has spearheaded efforts to clean up Hardrock mine land sites. Of particular interest to today's hearing, Director Cabrera and his team, they've developed a new prospective purchaser agreement process which allows the state to take control of abandoned mine sites that pose a critical threat to public health and the environment in exchange for providing narrow liability protections to parties not responsible for the initial contamination. So I want to thank Director Cabrera for getting up early this morning. I know it's early in Arizona. And thank you again, Mr. Chairman, for leading this important hearing.
And we're now turning virtually to hear Mr. Cabrera.
Senators Merkley and Duckworth, ranking members Wicker and Loomis, Senators Risch, Heinrich, and Kelly, and members of the committee, thank you for this opportunity to express my support for Senate Bill 3571. Most abandoned mines in Arizona ceased operations by the 1920s. These pre-regulation hard rock mines scatter the landscape, leaving behind mine waste, tailings, discharging adits, and open shafts. I would be remiss if I did not mention that the risks and impacts of these abandoned pre-regulation mines are very different from modern, heavily regulated mines. This common sense distinction was recently affirmed by both the US EPA and the DC Circuit Court of Appeals. But there is no doubt that pre-regulation abandoned mine lands pose a risk to public safety and health and continue to degrade the natural environment. Over 120 Arizona stream miles are listed as impaired under the Clean Water Act for heavy metals, frequently associated with abandoned mines. These streams feed larger watersheds that people depend on for recreation, irrigation, ranching, and are home to more than 150 endangered or threatened species. One of these impaired streams is Pinto Creek in Gila County, Arizona. The former Gibson mine site, which had been gifted to the Franciscan friars in 1969, and whose previous owners and operators no longer exist, was the single largest copper source to the Pinto Creek watershed. Since 2006, significant reclamation activities have been carried out through public and private partnerships, including ADEQ grants. Despite significant efforts, including a 75% reduction in the copper loading to Pinto Creek, the former Gibson mine continues to be a source of copper concentrations to Pinto Creek, and at every turn, the specter of liability slows down the work. ADEQ has worked with public and private partners to address 9 legacy mine sites since 2015, and I can assure you that liability concerns are a frequent obstacle. In 2 of the 9 sites, ADEQ signed a prospective purchaser agreement with new owners before the purchase. Arizona is one of a growing number of states with statutes that address liability issues associated with buying, selling, or developing property that has been contaminated. However, these state agreements do not protect partners who are not purchasers, and in any case do not limit federal actions and therefore liability associated with the Comprehensive Environmental Response Compensation and Liability Act or the Clean Water Act. Providing meaningful incentives and protections to our partners that are implementing work on the ground will allow ADEQ and others to continue to do work and expand work. CERCLA and the Clean Water Act contain joint and several liability as well as other provisions that are helpful to holding responsible parties liable in the today. These same provisions only serve as obstacles and barriers to addressing pre-regulation abandoned mine sites where the responsible party no longer exists. And given that the U.S. General Accounting Office reports that about 22,500 abandoned mine features across the U.S. pose or may pose environmental hazards, we need solutions, not barriers. Addressing Good Samaritan's exposure to liability via the pilot program proposed in Senate Bill 3571 is a critical first step in allowing states, tribes, new owners, nonprofits, and volunteers to accelerate cleanups at abandoned mine lands. The Environmental Council of States, the national organization of states' top environmental leaders, is encouraged by and enthused about this bipartisan proposal to spur environmental remediation and source water protection. There are others who have opposed Good Samaritan protection since 1999. The first Good Samaritan bill was introduced in Congress. These voices focus on the possibility of abuse rather than the progress through real projects. This bill, if passed into law, will result in beneficial uses instead of hoping for blame and in reclamation that replaces resignation. And if coupled with funding of Section 40704 of the Infrastructure and Investment Jobs Act for abandoned hard rock mine reclamation, Congress will create a turning point in abandoned mine land reclamation that will make a significant and lasting difference in our precious surface waters and environment. Thank you, and I'm happy to answer any questions that you may have.
Thank you very much, Director Cabrera. And we're now going to turn to Lauren Pagel, Policy Director of Earthworks. She is an expert on mining, oil, and gas policy and has worked to protect communities from impacts of extraction for several decades. She has led Earthworks' team for over a decade, has served as co-chair of the Methane Partners campaign since 2019. Welcome.
Thank you. Thank you for the invitation to testify on 3571, the Good Samaritan Remediation of Abandoned Hard Rock Mines Act of 2022. My name is Lauren Pagel. I'm the Policy Director at Earthworks. I really appreciate the opportunity to discuss ways Congress can help address the cleanup of abandoned hard rock mines and improve Good Samaritan policies. Earthworks is a nonprofit organization dedicated to protecting frontline communities and the environment from the impacts of mineral and energy development while supporting a rapid, just, equitable, and fair transition to renewable energy built from responsibly sourced materials. Earthworks supports S3571's goal of cleaning up abandoned hard rock mines that pollute ancestral public and private lands. Good Samaritan policies can assist in addressing the problem of abandoned mines, but Good Samaritans alone are not the solution to cleaning up the hundreds of thousands of old mines in the West. In addition to Good Samaritan policies, Earthworks supports the Biden administration's fundamental principles for domestic mining reform, as well as S4083, the Clean Energy Minerals Reform Act of 2022. A fully funded hard rock mining reclamation program paid for via a reclamation fee similar to what the coal mining industry pays is an essential part of getting abandoned mines cleaned up. Financial assurance provisions that reduce the risk and consequences of legacy pollution are also key, including EPA financial assurance requirements for the hard rock mining industry under Section 108B of CERCLA. Some important improvements to S3571 would ensure communities and Western waters are protected while also giving appropriate Good Samaritans limited liability relief for low-risk cleanup projects. To ensure waters of the U.S. are adequately protected, Earthworks recommends to limit the Good Samaritan liability waiver under the Clean Water Act. A limited liability waiver should include only certain point source discharges under Section 402, and this 402 waiver should be non-transferable and terminate if water quality conditions worsen or the Good Samaritan cleanup process ends. Good Samaritan projects should not include dredge and fill activities under Section 404, nor reopening of old adits on public lands, such as what happened at the Gold King mine disaster in 2015. On public lands, investigative sampling permits should be limited by scope and number and subject to public review. EPA can coordinate with the Land Management Agency to protect against pollution from mineral reprocessing and ancillary uses. Earthworks also recommends that the longstanding Clean Water Act citizen suit provision for affected individuals and communities be retained in any Good Samaritan policy. These provisions help hold our government accountable and allow affected persons to seek judicial review to protect the environment when permitting agencies fail to do so. Earthworks also supports Good Samaritan projects compliance with NEPA, which S3571 currently requires. NEPA waivers and categorical exclusions prevent Americans from having their voice heard on projects, and we are glad to see full compliance with NEPA in this bill. We also urge compliance with the National Historic Preservation Act, which is very important to tribes in the West. Earthworks is eager to work with the subcommittees and the bill sponsors to create Good Samaritan policy that's carefully crafted to safeguard against potential inadvertent misuse or abuse and ensure that downstream communities, tribes, watersheds do not end up further polluted. This is especially important since most hard rock mining occurs under the 150-year-old general mining law, a permissive statute whereby the mining industry claims public land as their own, almost entirely for free and at great expense to public, especially Indigenous communities. Good Samaritan policies are a small slice of a larger challenge of crafting more responsible mining policies in the United States. Swift action is needed to prevent future mining pollution and adequately address the larger scope of abandoned mine reclamation. Meaningful reform of our nation's mining laws and regulations will create jobs and protect water and Western communities from mine waste. Thank you so much for this opportunity to present Earthworks' views on these important issues.
Thank you very much for bringing your expertise to bear. And we're going to turn now to Chris Wood, the President and CEO of Trout Unlimited. Trout Unlimited is a national nonprofit organization with 300,000 members and supporters dedicated to conserving, protecting, and restoring North American cold water fisheries and their watersheds. Chris Wood had previously served as a senior policy and communications advisor to the Chief of the U.S. Foreign Service. Welcome.
I think I turned it off. Thank you for inviting me to testify on S3571. TU strongly supports this bill and appreciates the excellent leadership of Senators Risch and Heinrich, although perhaps not Senator Risch's criticism of my hunting, as well as the other 16 other bipartisan co-sponsors. For decades, TU has worked to restore abandoned mines from the coal fields of Appalachia to the Rocky Mountain states. And we stand ready to work alongside our state and federal agency partners, landowners, the mining industry, and other environmental groups to implement low-risk pilot projects that S3571 would authorize. I often describe TU as the patron saint of neglected environmental causes, and no issue is more neglected than the damage caused by abandoned mines. The EPA estimates that 40% of all Western headwaters are polluted by abandoned mines. These headwater systems are the sources of our coldest and cleanest water. They provide refuge for many species of native trout and salmon. More than half of these polluted streams are important sources of drinking water. Two primary challenges limit abandoned mine restoration today. The first is a lack of funding. Unlike every other commodity that is developed off of our public lands, mining companies do not pay a royalty on the production of minerals. Coal mining companies, by contrast, have contributed over $11.5 billion into the Abandoned Mine Reclamation Fund, which fund has been used to great efficacy to clean up legacy coal mines across Appalachia and the western states. The second major challenge to abandoned mine cleanup are liability issues. Good Samaritans, organizations like mine that had nothing to do with the creation of pollution, could spend a few $100,000 making waters more swimmable and fishable and get to perhaps 95% of Clean Water Act standards. But it may cost a few $1 million more to achieve that extra increment of 5%. So the organization that materially improved water quality could then be labeled by the government as a potentially responsible party, or could be subject to a citizen suit and compelled to get to 100% of Clean Water Act standards. Abandoned mines are a pervasive problem, but the solutions for fixing them are usually straightforward. Over the past few decades, TU has completed more than 40 separate abandoned mine cleanups across the West, using the limited legal tools that are available to us for dealing with waste rock piles through CERCLA and non-point source provisions of the Clean Water Act. But there is so much more that we could accomplish. TU members love the positive impact these projects have on trout populations, but it is important to remember that gravity works cheap and it never takes a day off. When we reduce toxins from entering our waterways, we provide significant water filtration benefits for downstream communities. We know how to implement low-risk mine cleanups to improve watershed and community health. The problem is that two of our nation's most important environmental laws, the Clean Water Act and CERCLA, treat those who want to clean up pollution as if they are polluters themselves. Unless restoration results in discharges meeting 100% of Clean Water Act standards, Good Samaritans could be held liable for the remaining pollution. Today, the perfect stands as the enemy of the good. S 3571 would establish a new 7-year pilot program administered by the EPA to permit up to 15 Good Samaritan cleanup projects. These low-risk projects must produce measurable improvements in environmental conditions. The bill expressly prohibits mining activities from Good Samaritan protection. There are no mining loopholes in this bill. Lastly, only sites that are truly abandoned are eligible. No one who caused the pollution will get off the hook. Taken together, these pilot projects will allow for Good Samaritans to make our water more drinkable, fishable, and swimmable. There is no constituency for orange rivers. We should be able to work together to pass this carefully crafted, tailored pilot program, learn from it, and then get to work at scale to recover the lands and waters upon which we all depend. Thanks for the opportunity to testify today.
Thank you very much. And we'll now turn to Jim Augsbury. And wanted to make sure, are you introducing Jim? No.
I'm not, but I can.
Well, you'd be most welcome to.
Thank you. Jim Augsbury is the head of the Western Governors Association. It is the 17 Western states, as I recall, and the island governments. The good work of the Western governors is very bipartisan. They alternate between Democrat and Republican governors in terms of the leadership of the group, and they address issues that are typical problems that are common within those Western states. They also have fellows from a lot of federal agencies that can contribute expertise. So you get a very balanced set of recommendations coming out of the Western Governors Association. I used to be on the staff council of the Western Governors Association when I was a general counsel to my governor, Jim Geringer of Wyoming, and found the work of the Western governors to be especially pragmatic, common sense, helpful, bipartisan, and very targeted to address common issues of concern to the Western states. And Jim Augsbury does a wonderful job leading that organization. Welcome, Jim, to the Senate committee.
And we're delighted to have you, and that type of bipartisan record on issues in Western states is so appropriate on this particular issue.
Well, thank you very much. Chair Merkley, Ranking Member Lummis, my name is Jim Augsbury. I'm the Executive Director of the Western Governors Association, a fiercely bipartisan organization representing the governors of the 22 westernmost states and territories. WGA is an instrument of the governors for bipartisan policy development and information sharing and collective action on issues of critical importance to the Western United States. It's an honor to join you today. Thank you for your attention to the important issue of abandoned hard rock mines and considering S3571, the Good Samaritan Remediation of Abandoned Hard Rock Mines Act of 2022. I would like to acknowledge Senators Heinrich and Risch for their bipartisan leadership on this issue and the strong bipartisan support that the legislation has attracted from other Western senators. Western governors have had formal policy on this issue and liability protections for Good Samaritans since 1995. Their current policy is articulated in WGA Policy Resolution 2021-09, cleaning up abandoned hard rock mines in the West. That resolution, included with my written testimony, states, quote, Western governors call on Congress to legally protect Good Samaritans who clean up abandoned mines, including local and state governments, from becoming legally responsible for any continuing discharges from the abandoned mine, unquote. The resolution also specifically supports the kind of pilot program authorized by S3571. Again, quoting from the resolution, governors would support legislation establishing pilot projects, including pilot projects under state-led programs, to address liability issues for Good Samaritans at individual sites to help pave the way for comprehensive legislation if comprehensive legislation addressing these issues is not possible in the short term. The issue of abandoned hard rock mines has concerned Western governors for decades, and they encourage congressional action now. The number of problematic mines is unknown, but the Government Accountability Office reports that tens of thousands of mines present confirmed environmental or physical hazards. To repeat the astonishing statistic already cited by Chair Merkley and Chris Wood, the Environmental Protection Agency estimates that 40% of Western headwaters have been affected by abandoned hard rock mining discharges. Discharges of acidic mine drainage degrade water supplies for working lands and communities. They harm aquatic species, and they lead to losses for recreation economies. The scope of this problem is massive. Federal agencies estimate that the total cost of addressing these hazards is on the scale of tens of billions of dollars. Cleanup of abandoned hard rock mines is impeded by insufficient funding, incomplete data establishing the scope of the problem, and a lack of common agreement concerning remediation needs and priorities. Another significant impediment is the potential legal liability of Good Samaritans who are willing to undertake remediation projects but cannot bear the risks of being sued for their actions. Such parties who otherwise would have no responsibility for the pollution at abandoned hard rock mine sites can significantly increase the nation's capacity to access and remediate these mines. Good Samaritans can be a powerful engine of abandoned mine cleanup, but only with funding and liability protection of the kind offered by S3571. Under the bill, EPA is responsible for determining Good Samaritan eligibility. Western governors submit that states are more than qualified to assist in making that determination. Many states have agencies that administer the Clean Water Act, regulate and require financial assurance for reclamation of hard rock mines, remediate affected waters, and implement abandoned mine programs. These states are suited to help determine which entities should be eligible for Good Samaritan status and to review and determine the adequacy of Good Samaritan reclamation plans. States are equipped to address the complexities associated with checkerboard land ownership in the West, and they can facilitate the kind of collaboration that is essential to address cross-boundary, cross-jurisdictional resource management issues. Good Samaritan legislation to recognize state authority and the expertise that states can bring to bear with respect to the pilot program's implementation. Thank you again for providing the opportunity to submit testimony on behalf of Western governors.
Well, thank you all for your expertise. We're going to turn to questions now, and I'll jump right in, followed by Senator Lummis. followed by Senator Shelley Moore Capito. Great to have you. If you're still, okay. Okay, so submitted for the record. I'm familiar with a site in Washington State called Holden Village. It's a former copper mining, primarily copper mining camp, and it's now a Lutheran retreat center. And when I was there more than a decade ago, I noticed bulldozers at work and asked what was going on, and they said, well, they're trying to figure out how to cap the tailings, and specifically the challenge of cyanide trickling out from the tailings. And cyanide was used to dissolve the metals in a lot of hard rock mining. How big of an issue is cyanide leaching into our streams and affecting the health of streams? And Chris Wood, I thought we might have an answer for that.
Cyanide's pretty bad for fish. And it's not alone in terms of the toxins that are caused by abandoned mines. It's zinc, lead, cadmium. I mean, it's the alphabet soup that you described, Senator Lummis, earlier for this committee. It's applicable to how many negative effects can happen when minerals oxidize. They're exposed to oxygen, and then they leach acid mine drainage into rivers. And it's not just bad for fish; it's bad for people too. As I mentioned, half of the abandoned mines in the West, it's estimated, negatively affect drinking water supplies. So it's not just harming fish, it's harming people as well.
Yeah. The stream that ran through that village was completely dead. I mean, no fish, nothing lived in it. And so it remains in my mind how important it is to be able to do cleanups. And I just want to be clear, and I'll ask you this, Lauren Pagel, under this legislation, this would not allow people to go in and kind of reprocess tailings for further extraction, reapply any sort of additional chemicals to dissolve metals. In other words, this is not protection for kind of going in and remining, but this really is truly about cleanup.
It is, and that's a really important distinction between mining and Good Samaritan cleanup that this bill makes.
Great. I'm going to turn this over to Senator Lummis.
Well, thank you, Mr. Chairman. Mr. Wood, congratulations on the good work of Trout Unlimited to advocate for our clean waters and our fisheries. I note that in August, Trout Unlimited, with 6 other conservation organizations, submitted joint comments with recommendations for the interagency working group regarding meaningful Good Samaritan proposals to remediate historic AML sites and reprocessing of mine tailings and waste. The comments did highlight the Clean Water Act and CERCLA as 2 primary barriers to making progress on AML reclamation. Can you describe how targeted conditional liability protections in reclamation efforts can help speed up the progress on cleanup of legacy abandoned mine lands?
Yes, ma'am. Thank you for the kind words about Trout Unlimited. We appreciate that. As I mentioned in my testimony, one of the challenges this puts me in a very difficult situation because there's not a stronger advocate for the Clean Water Act than Trout Unlimited. Fish need cold, clean water every day. Trout do anyway. The challenge, though, is that as vital as that law is, it is meant to stop people from polluting. It doesn't enable people to clean up the effects of pollution. And so, as I mentioned, we have the ability to go in with a lot of these tailings, for example. The solutions are fairly straightforward. They're minor engineering problems with some of these places. We're not talking about Superfund sites. You dig a hole, you line the hole, you bulldoze the tailings into the hole, put an impermeable liner over it, put parent material over it, dig a French drain, and then you can walk away from a lot of these sites. But we can spend a couple of $100,000 to do that kind of work on a site and to bury these tailings. And we might be able to get to 95%, 98% of Clean Water Act standards. But it might be another $2 million. You might need to do a constructed wetland to get to 100%. And once you start dealing with moving water, running water, it implicates the Clean Water Act. And you're required by law to get to 100%, or we would become a potentially responsible party in the government size and liable to citizen suit from anyone. So it's a wonderful law. We don't want to change the Clean Water Act in any way, shape, or form. We just want to demonstrate the prowess of communities, of Good Samaritans to clean up these abandoned mines and to do so in a manner that, makes the environment materially better, and then hopefully we can work with Congress to take this idea to scale.
Well, thanks for your willingness to participate and put your financial wherewithal behind these projects. Mr. Ogsbury, how applicable are pilot projects for low-risk AML sites like those in my home state of Wyoming? And is there room to implement Good Samaritan remediation more broadly?
Thank you, Senator Lummis. Again, there are tens of thousands of hazardous abandoned mine sites across the nation. We're looking under this legislation at just 15 pilot projects, and we think that would be a great start, but we want to learn from these projects and maintain momentum. And the best way to build upon these pioneering projects is to ensure that we apply lessons from the projects to future Good Samaritan comprehensive legislation. Western states are an excellent laboratory for testing the system. Rather than contemplating an extension of the pilot projects, we would hope and prefer that the lessons learned from the pilot program be used to inform comprehensive legislation. In the meantime, these pilot projects will help us further understand how to best design projects to make them both attractive to Good Samaritans while ensuring that environmental cleanup quality is maintained. And we'll also be able, hopefully, to make sure that Western states have a leadership role in the design and implementation of the program.
Thank you. And my last question is for Director Cabrera. Can these permits be designed in a way so they are limited in scope to make sure that no one can mine, explore, or conduct other activities outside the scope of the permit under this legislation?
Senator Loomis, absolutely. The EPA will have the ability to set forth specific permit conditions to the particular pilot project. And as far as I read the legislation, EPA is going to have a broad authority to write permit conditions. And as long as the applicant agrees to those permit conditions, the permit may limit many of the activities that occur on the site in terms of scope and ability. The law itself is very narrow and only allows for very narrow reprocessing of materials without additional mining. So the answer to your question is yes.
Thank you all. Mr. Chairman, I yield back.
Thank you. Director Pagel, in your testimony, you were mentioning several specific things that you would like to see in the bill. It wasn't clear to me if you were commenting on points that have already been incorporated or points that you think still need to be incorporated.
These are points that we think still need to be incorporated, and we're looking forward to working with the sponsors, you all on the committee, and Chris and others to make sure that any Good Samaritan legislation is really protective. We're working directly with communities on the ground who have been impacted by mine waste or mining, and we would just want to make sure that downstream communities, especially Indigenous communities, are adequately protected and that there's not some unintended consequences. Earthworks, Chris was reminding me that the first time we testified together on this issue supporting Good Samaritan liability relief was 2006. Not that much has changed, except maybe now I wear these reading glasses. But the liability relief that Good Samaritans want is something that we support and want to work to make sure that any bill that passes gives that liability relief, but also really protects water and communities on the ground.
Thank you. And Director Wood, it's been mentioned that you've been engaged in this conversation for a long time, and the earlier testimony said this was first looked at in the early 1990s. What has been the primary concern that has prevented this from becoming law previously?
Senator, I think it goes back to something I suggested earlier. The Clean Water Act and CERCLA are two of our most important environmental laws. And I think people have been concerned that we would somehow use this effort to weaken those bedrock environmental laws. And I think another issue is that people were concerned about the scope and the scale of permitting a Good Samaritan program writ large. And while I agree with Jim that we do need to do that, ultimately the beauty of this bill is that it's 15 pilots over 7 years. And so we can actually learn from the work over the next 15 years and then take those lessons learned and apply it more broadly.
I'm trying to remember the details, and I'm not remembering them of a previous environmental accident. And I wasn't sure if it happened during an attempted remediation, but I think it was a mine that was full of water that was contaminated that was released into a stream and caused some devastation. Can you remind us of that, and how do we avoid that, something like that happening again?
So that was I think that was the Animus. I mean, it happens every day, to be clear. It's happening on tens of thousands of abandoned mines. But on that one, there was a cleanup, a contractor to the EPA, I believe, that was cleaning up some big adits that were plugged, and they gave. But it's important that kind of a cleanup, that's not, we're talking about lower risk projects, not projects that, would qualify for Superfund cleanup. These are mostly tailings piles or draining adits, which are much smaller in scope and scale.
And Ms. Piggle, is that the kind of thing that it's in your mind when you're concerned about potential downstream impacts?
Yes, there's always, I think the focus on low-risk projects and the pilot projects is great and will hopefully mitigate anything like the Gold King mine disaster in Colorado happening. But just, things do go wrong, and just making sure that there's adequate protection if water quality is made significantly worse than it was previously is something that we remain concerned about, and we want to make sure that there are adequate protections to ensure that doesn't happen.
And Director Wood, you mentioned that that particular disaster involved unplugging something. I didn't catch what it was you were talking about.
Adits, holes. I think they were doing some drilling to relieve pressure from these adits, and I don't exactly know the details of what happened there, but it was a much more larger scale engineering project than the 15 pilots that are contemplated in this bill.
And Director Augsburry, if we do nothing, if we don't have this bill, is it fair to say that very few remediation projects will take place?
I believe that's so. As Chris has mentioned, we've got two big impediments, which are funding and liability protection. Congress has started to address the funding issue, and that can really be unlocked with the Good Samaritan protections anticipated by S 3571. And I would just add that we're talking about the Gold King mining disaster, and although that wasn't the kind of site that would be subject to this legislation, it did demonstrate to the public the dangers that these mines present, and really the acute economic impacts. Fisheries were closed, recreation along the Animus came to a standstill. It's a very river-dependent economy in that area. And I know fishermen were loath to get back because of the contamination, but more typically, acid mine drainage has diffuse economic impacts over long periods of time. Contaminated water is more expensive for municipalities to clean up, to treat to drinkable water standards. Agricultural producers suffer reduced crop yields when they're irrigating with contaminated water, and it also harms those aquatic ecosystems essential to good fishing and hunting and birding. So I would hope that inaction is not an option.
Director Augsburry, just to be absolutely clear, these are abandoned mines. This is not a situation where a company that has been involved in the mine, still has liability, still is, reachable, could transfer a mine to a nonprofit and avoid being responsible for the challenges they may have created.
That is my understanding of the legislation, yes, sir.
And is that everyone's understanding of the legislation? Yes.
Yes.
Senator Kelly.
Thank you, Mr. Chairman. Before I begin, I ask unanimous consent to enter into the record 12 letters of support for this legislation from states, NGOs, and advocacy groups.
Without objection.
Director Cabrera, thanks again for joining us today. I want to ask you to expand upon your testimony. You mentioned that 120 stream miles are considered impaired under the Clean Water Act due to abandoned mine sites. Now, how many of these streams are tributaries of the watersheds that provide most of Arizona's drinking water, like the Colorado River, the Salt River, the Verde River, and the Gila River?
Senator Kelly, thank you for the question. Of the 120 impaired stream miles, 93 of those miles are in watersheds of these major Arizona rivers. And while none of these stream miles are directly used for drinking water, they're all in the watershed. And as the drought continues and the assimilative capacity of our rivers and streams is reduced, in other words, the flow is reduced, so its ability to accept pollution and contamination is also reduced. It becomes a much, much larger problem for all of our limited drinking water sources. That's why the Arizona legislature a number of years ago produced a joint resolution led by Representative Griffin to recommend to Congress that we pass abandoned mine legislation.
So 93 out of 120 of these streams go into these rivers where drinking water comes from. That's about 78% of those. So that's significant. And can you briefly discuss the risks posed by abandoned mine sites to our groundwater aquifers? Are there any sites which pose a particular acute risk to groundwater, which is used for drinking water?
Thank you, Senator. One thing to understand about the state of Arizona is that every drop of aquifer is considered a drinking water source. That's actually very rare in the United States. But we're a desert region and water is very precious. And so, for the most part, for us, groundwater equals drinking water. One example in the state of Arizona is a site that was studied by the Arizona Department of Health Services because it had high levels of metals in groundwater in a rural location where lots of private individuals were using that groundwater as a primary drinking water source. That particular site we are working with, and we're trying to address the surface water contamination that seeps into the groundwater sources. So it is a very real risk to our aquifers and groundwater. And again, in the state of Arizona, all of our groundwater, for the most part, is considered a drinking water source.
Yeah, it sounds like a serious risk to our drinking water. And as I talked about previously, this is going on at a time when we're preparing to do more with less water from the Colorado River. So we need to ensure that other sources of drinking water, our groundwater, is protected. Director Cabrera, I understand that ADEQ has identified some of the most at-risk orphan mine sites and is working with the landowners on remediation. Can you explain how CERCLA and the Clean Water Act pose challenges when working with landowners to address these abandoned sites?
Yes, Senator. For many abandoned mine sites, there are no existing responsible parties for the contamination. Instead, there are often private landowners without means or knowledge to address the issue, or the sites are on public lands. And so private landowners in particular often bought without knowledge a legacy site And they never created the problems that were created a century ago. Now, why that's problematic is because under the Superfund law, CERCLA, which we've mentioned, there are 4 types of potentially responsible parties. There's current owners and operators, there's past owners and operators, there's generators and parties that arrange for the disposal or transport of the hazardous substances, and then there's transporters of hazardous waste that selected the site where the hazardous substances were brought. In a 2015 report on cleanup of abandoned mine lands, the Congressional Research Service states that at least 2, but in my opinion, more likely 3 of those categories might apply to Good Samaritans or innocent landowners who attempt to clean up an inactive or abandoned mine. Now, circular liability in particular, we have to understand that it's retroactive. So parties, any of those 4 potential responsible party categories are held liable for acts that happened before the laws even existed. The liability is joint and several, which means that any one potentially responsible party can be held liable for the entire cleanup, and it is strict. A responsible party cannot simply say that they were not negligent or that it was not their doing. And so this poses a heavy burden. These laws do a really good job of holding people accountable in the today, but what they do is they form barriers and obstacles where responsible parties who actually did the contamination are no longer available. So this set of liability provisions poses an asymmetric risk for an innocent landowner or a private party or an NGO or a volunteer or a state when the land in question is worth a fraction of the cost of cleanup. And so the risk reward becomes very, very difficult, and most parties simply choose to do nothing.
Well, thank you, and thank you for your testimony. Mr. Chairman, I've got some more questions I want to submit for the record.
Absolutely, without objection.
And also, I want to just thank everybody for being here today. And Chris, nice to see you again, and appreciate everybody showing up for this to have this issue addressed. I mean, it's important we get these cleaned up. The water situation we have in the state is challenging, to say the least, and we've got to protect our groundwater from the runoff from these hard rock mines. So, thank you, Mr. Chairman.
Well, thank you very much, Senator Kelly. Thank you for your hard work to address this really critical challenge. It's a challenge, I know, in Arizona, as you mentioned, every it's an issue really throughout our set of western states, as demonstrated by all the senators who have been engaged in this conversation. So I appreciate your contributions and efforts. So thank you to all of our witnesses for being here today and for bringing your expertise to bear. I'd like to ask unanimous consent to submit for the record materials that relate to today's hearing. Hearing no objection, so ordered. Senators will be allowed to submit written questions for the record through the close of business on Wednesday, October 13th, 2022. The team will compile those questions, send them to our witnesses, and ask our witnesses to respond by Wednesday, October 27th. That would be very helpful to us in taking this process forward. And with that, this hearing is adjourned.